Hi, Mariana, Dr. Kravtsenyuk. How are you?
Good, thank you.
I'm very happy to have you here as my guest today for the Wicked series that we do for women in Canadian criminal defense. It's very exciting to see you and to talk to you about what you do, because what you do is actually important for many of our criminal lawyers who practice specifically in the area of mental health law. You are a forensic psychiatrist, and I will let you introduce yourself more, and we'll start with that, and then we'll get more into what you're doing. But I'll let you start with an introduction about yourself, Doctor.
Thank you, Maya. Thank you so much for this kind introduction and invitation. I'm a forensic psychiatrist, and I finished my general psychiatry training at the University of Alberta 2015. And also I completed subspecialty training in forensic psychiatry at the University of Toronto in 2016. Since then, I have been working in various jurisdictions across Canada as a forensic psychiatrist and have quite diverse practice settings, ranging from working on secure rehabilitation units in forensic hospitals, outpatient forensic clinics, correctional clinics, and provincial federal institution, as well as providing services as expert assessor for any proceedings in various matters, whether it's criminal or civil matters. I have been also engaged in different portfolios within sort of medical field and teaching undergraduate, graduate, and postgraduate students. I joined uh, University of Toronto as a faculty member about over the last year, and very privileged to work with a group of forensic psychiatrists where I trained to obtain my forensic psychiatry subspecialty. So since then, I have been focused more on conducting court-ordered assessment and providing care to the individuals under Provincial Criminal Code Review Board. So I also provide assessments for the mental health court in Toronto, and provide forensic services in Northern Ontario as well. My practice, my private practice includes third-party medical legal assessments for criminal and civil proceedings.
And on that point, if we can just, in broad terms, just explain what the differences are between the criminal and the civil side of things.
So, with respect to criminal forensic psychiatric practice that I have, it relates to matters that are within the federal jurisdiction. Any medical legal questions that are related to not criminally responsible verdict, fitness to stand trial, risk assessment, for proceedings under criminal code review boards, or sentencing proceedings, or other legal questions within the jurisdiction of federal law. They will be under, I would say, my forensic criminal portfolio.
Mhm.
And I work with criminal defense lawyers or Crown prosecutors to do my best to answer those questions with respect to those matters. Civil questions relate to various matters depending on jurisdiction. So in my practice, I address a number of questions related to disability, related to potentially law related to segregation, class action lawsuits, as well as some regulatory bodies will also have number of questions that might fit into the domain of civil forensic psychiatric assessments, and they related to fit for duty assessments, anything that would incorporate any questions with respect to public safety, threat assessment,
Mhm.
in various domains of civil law, and it's very province specific. So it's quite diverse what you can be asked
Yeah.
to answer, but it's very interesting part of my practice, and certainly it evolves as time goes, and you as a professional, you feel very stimulated by the questions being asked because the law is quite diverse when it comes to civil matters, and from jurisdiction to jurisdiction, there are certain nuances you need to acquaint yourself with.
All right. And how long have you been doing this, Mariana?
I have been working as an independent forensic psychiatrist for about 10 years, nine and a half
Nice.
years.
And you do testify as an expert, right, in court cases?
Yes, I have been qualified as an expert witness in the matters related to fitness to stand trial and criminal responsibility, risk assessment, sentencing proceedings, and civil matters.
Okay, so let's focus more now on the criminal side of things because most of our viewers are criminal lawyers and more specifically criminal defense lawyers. One of the things that is important, I think, for many of us criminal defense lawyers who take on mental health cases is what type of information is a forensic psychiatrist looking for when we're talking about, let's say, a fitness assessment or an NCR or a dangerous offender hearing? Like, what information do we need to provide and that will help you in your assessments?
I would say, in a nutshell, as much information
Yeah.
as people can provide to me an expert would be better. So when I'm asked any medical legal question, I conduct fairly comprehensive and fulsome assessment that incorporates not only interview with the individual or was the accused person, but also file review, and incorporates legal file review. Ideally, I always ask for any clinical files, and I find sometimes it's challenging for um, criminal defense lawyers or Crown Prosecutor Office to really have access to some of that
Hmm.
data. Sometimes it's available and it's really informative for expert to have some of that file information, especially if it's related to some specific question, whether it's mental status of the accused at the time of the offense and
Yeah.
criminal responsibility. So as much fulsome data or information clinically, legally about the file, about the individual that is being assessed or questions are being asked about, the better the assessment, the more informed the expert is. I also appreciate when I have additional information from collateral sources. So some criminal defense lawyers will have very good relationship with their client in terms of knowing some of the family
Yeah.
members or close supports, and they can connect me with them in
And
quite
that will be
efficient.
important for your job to talk to people who know the accused. Okay.
Absolutely. And I tell my clients, I always say, I would like to speak to someone who knows you better than I know you, or anyone else who known you for a long time and can really reflect on some of my questions. So that's really helpful if I have those contacts. And again, some of the lawyers will have that access quite efficiently
Yeah.
and will connect us. So that is really helpful. And overall, I think generally additional part of the assessment sometimes involves psychological assessments. It's really helpful if the file has previous psychological assessments or
Hmm.
neurocognitive assessments or Gladue reports or any other relevant reports that were done in the context of proceedings previously related to mental health. It's informative, helpful, and it helps to really consider all the factors to derive to the most accurate opinion that we can form.
But I want to ask you here on this point because what we see with many, especially in cases, mental health cases with individuals accused who are dealing with mental health problems, um, the challenge is they also, many of them unfortunately come from disadvantaged backgrounds. So they're cut from their families. There is nobody that we can talk to who knows them. And there are no previous reports or assessments that exist or that we know of or that we have access to. So, I mean, how can the assessment happen in these types of cases where we really don't have access to all that information? And I agree, like the more you know about a client or a patient, the more informed your um, decision or your assessment is going to be. But the challenge I find in many of these cases is that we don't have all this additional information. So how can you still be able to have an accurate assessment without the benefit of all that?
And that's a really good question because we know that if we look at the population within criminal justice
Yeah.
system, there is overrepresentation of certain ethnic groups,
Mhm.
advantaged, marginalized societal
Yeah.
groups. So, in my opinion, as an assessor, we have to have understanding, knowledge of certain cultural aspects of presentation of these individuals. And if we might not have that understanding, we should identify when we need to inquire additional consultation or additional information with respect to cultural, ethnicity, background, traumatic past. It's very important to consider those aspects in the assessment. Those people, you're correct, Maya, they frequently don't have any supports
Hmm.
and
Yeah.
no past histories. So by knowing their background, by knowing the systemic aspects, asking them questions related to some of the nuances in their history, culture, upbringing, will help us as an assessor to really, I think, collect enough data points to understand these individuals better. From my perspective, I certainly find that I need to understand more in depth certain cultures overrepresented in criminal justice systems, such as indigenous.
Yeah.
There is clear overrepresentation of indigenous population. And as someone who works in forensic mental health, I think we must have expertise, understanding, and training in those areas to really understand where there are limitations of our assessments and expertise and where we need to really consider some of those vulnerability factors into our assessments.
And so for these types of cases, let's say in the case of indigenous accused, then as you mentioned, a Gladue report will be important. So if there isn't one already, then will you ask that the court order one and that um,
I would usually talk to the party retaining me as an expert, whether it's defense or crown
yeah.
prosecutor. I will ask what the possibility to complete one. I had few cases where I was the first individual who identified the ethnic background
Hmm.
of the accused. And once it was identified in the court immediately issued Gladue report order. So it's helpful to sit and really have a thorough assessment and interview of the individual. And sometimes they will provide you a lot of information. Of course, it depends on case by case. But in these few cases that I had in my practice, certainly it was helpful. And individuals didn't have any support, no other collateral sources. But they were able to identify certain parts of their history that was helpful for the court to know, and it assisted them along their judicial journey.
And so, okay, if we focus specifically on the Gladue reports, what information specifically about that, um, I know you mentioned in general, but if we want to go more into specifics, what is it in a Gladue report that could help you as a forensic psychiatrist, in your assessment of the individual? What are you
So,
looking for in the Gladue report?
so I would say it all depends on what type of assessment I'm asked to do.
Right. So if we
I,
can clarify for the different types, then.
so I would say commonly, some information from Gladue report was in pre-sentencing proceedings or sentencing
Yeah.
proceedings. And the information that I find important is related to the risk assessment, to the roots of individuals' behavior, conduct that contributes to their cycle of criminality and frequent interaction with the law. I find it's informative for me as an assessor to understand the roots of aggression in specific case, to educate the court when it comes to the risk assessment, potentially describe what risk factors or protective factors this individual might have. And some of them are embedded in their culture, ethnicity, connection with their group, cultural group, how close they are, how involved they are, how important that was for them when they were growing up, or how traumatic that was for them when they were growing up. So I find
Well,
all those factors really inform my assessment.
okay, but then on that, isn't the criminal record in that case useful as well?
It is useful, and we know when it comes to, I think, indigenous offenders,
Hmm.
that criminal record is part of the information.
Yeah.
Very often, these are individuals that are in position and quite disadvantaged psychosocially. And sometimes looking at criminal record just gives us sort of a timeline and certain points of data. But we need to take that criminal record into context of
Hmm.
their life to really understand, as a psychiatrist, as a forensic psychiatrist, to understand why that individual went through that journey and why it was recurring, repetitive, what factors predisposed. So it having Gladue report, having additional information, and really understanding that criminal record in the context of all that helps to put that in what we call formulation of the risk, and ideally how to manage that risk down the
Right.
road.
Right. Now, Mariana, so this information here that you're looking for, it seems like it's very beneficial for a sentencing hearing and maybe for NCR. But then for fitness specifically, because fitness is a little bit different. It's more about the accused ability to understand proceedings. So what kind of information do you need, or are you looking for a fitness hearing?
So fitness assessment is focused on mental status of the accused at the time of the
Yes.
proceedings ordered. And as an assessor, I certainly appreciate any information related to recent clinical history, if available. Unfortunately, it's
Yeah.
not available.
Yeah.
Also, observation of the defense counsel, of their interaction with the
Hmm.
accused. And it's really helpful. I had few people reaching out to me, just giving me a little bit more context why fitness matters were even raised in the first place in the courtroom, what prompted those matters, and how their interaction with the accused was overall from mental health perspective. That is really helpful for me to understand. I also appreciate when I get a bit more education from the defense counsel or Crown with respect to what criminal matters this accused is facing. Because fitness, as much as I can assess individual with respect to fitness at certain moment of time, fitness can be fluctuating.
Yeah, it's
And
fluid. Yeah.
on fragility of their mental state, on the degree of their psychopathology, any past periods of deterioration or mental health issues from the past, and also depends how complex proceedings that they're facing currently in the courtroom. Are they going to be quite extensive, long, serious legal matters that this individual is expected to maintain their fitness over a prolonged period of time? And all these factors really help me to make the best formulation of fitness and educate the court with respect to fitness or fluctuating fitness over a period of time.
All right. And on fitness, because as you mentioned, it is fluid, like a person who is fit today may not be fit tomorrow. But usually, one of the things that we also try to do in a criminal case is that we try to rehabilitate the accused and get them back into a fit level so that they can participate again in a criminal proceeding. But then what is involved here? So what's the process of getting them back um,
So
into, yeah.
once the verdict of unfit to stand trial is
Mhm.
rendered, there are two pathways that are available to restore
Yes.
fitness is treatment order. And certainly as an expert, I am always ready to support treatment order if all the criteria for treatment orders are met in accordance with criminal code. And we need to have identifiable and treatable mental disorder that will be treated maximum within 60 days. So that's treatment order is fairly straightforward pathway to restore fitness, but we really have to be assured that we are dealing with individual whose verdict of unfit to stand trial mainly due to reversible or treatable mental disorder.
Hmm.
There are individuals that have more complex presentation, or I would say challenging to treat presentations, such as advanced neurocognitive conditions, neurodevelopmental condition, intellectual disability, severe intellectual disability, or conditions where it's very difficult to say whether it's combination of intellectual disability and psychotic illness. So when we can't really meet and satisfy all the criteria for treatment order, and we have individual who's found unfit to stand trial, those individuals are further forwarded to the Criminal Code Review Board jurisdiction, and within 45 to 90 days, they have their first hearing. And under the jurisdiction of Provincial Criminal Code Review Board, their matters are being addressed on yearly or as often as needed basis. And that fitness is being reassessed. And at some point, some of those individuals might be found permanently unfit.
Hmm.
So those are more complex cases, I would say,
And
and
rare. Yeah.
treat. However, I would say, and again, this is just my experience. I'm not speaking for any specific data, but as a practitioner, I think we see um, more and more aging population
Yeah.
within correctional system. And as we see more aging population, unfortunately, we will see a lot of cognitive decline. And those are conditions that become permanent. So these are individuals, unfortunately, with dementia that are under review board and frequently declared as permanently unfit.
Yeah. Yeah. Well, I mean, the thing is though, like hopefully these cases will be rare. We won't have they're more challenging and more difficult to deal with. But okay, so I mean, like it's good to know that I mean, um, like we have unfortunately these types of cases that we can encounter sometimes, and will then they'll be permanently, I guess, under the purview, I think, of the Ontario Review Board, right? Like in these types of
So
situations.
every province has a provincial
Yeah,
quasi-judicial structure
yeah,
as a provincial criminal code review board. In Ontario is ORB, Ontario Review
yeah.
Board. I have to say that the provisions for criminal code review board are really designed to first and foremost address safety of the public
Hmm.
and needs of the mentally disordered accused. So even if individual does end up under provisions of criminal code review board, during those hearings, as much as risk and public safety is being addressed, their needs also being looked after, and individual remains in a supportive therapeutic environment, whether it's in secure facility or community, but with quite well-rounded forensic service supports. So forensic system is quite comprehensive when it comes to care delivery, because we are dealing with typically complex chronic issues, risk, and those individuals, as much as like you mentioned, they end up in the system for a long time.
Yeah.
So there are certain pathways out of the system that are regulated by the law, but also even if they do end up over a long period of time,
Hmm.
our forensic service really assures that these are individuals whose needs are looked after and they receive care, supervision, support from multiple directions.
But I want to ask you here a question because, I mean, there are cases where it's inevitable. A client, a patient, s- I mean, he seriously has very serious mental health issues, and they have to go under the Ontario Review Board jurisdiction. Like some cases, it's obvious there is no other way to deal with this case. And at the beginning, many of the clients themselves are fine with that because, I mean, it's really the only option. But because it's a lengthy process being under the Ontario Review Board, that many patients or clients eventually get tired of it and they just want to get out. So, how can they get out of that system? How can they, like for those who are stuck and they just want to be discharged? What's the route for that?
So this is where we really rely on your colleagues to
Hmm.
provide really good instruction to the client with respect to entering the system
Hmm.
and exiting the system. It is a legal test. A significant threat to the safety of the public
Yeah.
is a test that basically holds individuals in the forensic system. As long as the test is met, the individual remains under the jurisdiction of Provincial Criminal Code Review Board.
Hmm.
And the pathway out of that is really to provide the board with evidence that that test is no longer met. And these are sometimes quite adversarial, contested hearings,
Yeah.
but I think fair hearings to the accused, to the NCR or unfit accused. And during those hearings, there are multiple professionals at the board. The board is quite multidisciplinary, not only legal and
Yeah.
medical representatives, there are also public members as a members of the board. So I think the spectrum of expertise is quite inclusive and comprehensive when it comes to those decisions. And we do rely largely on criminal defense lawyers to really instruct the clients on pathways out of system.
But okay,
And
so
as
let's talk though about this because I mean, most of the evidence at these hearings will come from the doctors, the evaluating doctors. They're the ones who will just prepare a report, and that's the bulk of the evidence. But what else more, especially, I mean, the client is still in a hospital. Like, what additional evidence can a defense lawyer here bring to that hearing to show the board that the client is fine? No need to keep them there.
I think when we look at assessment during those hearings, we look at risk factors, we look at protective factors.
Yeah.
And from my experience, I know that sometimes the defense counsel that really wants to demonstrate to the board that their client is much better than what's portrayed
Yeah.
by the treatment team. I think sometimes counsel might really emphasize on some of the strengths that their client has, and at times they will involve witnesses, additional witnesses like family members. They can, I mean, this is at the discretion of the defense counsel, that they will call to really provide the fulsome information for the board, because ultimately the board makes the decision with respect to
Right.
in order, conditional discharge, or absolute discharge. As expert witness at those hearings, I can only speak from my perspective of interaction with this individual, assessment by multidisciplinary team, what we know with respect to risk assessment. But defense counsel, I think, sometimes might emphasize on some of those positive aspects, and sometimes it provides more balancing view. I would say it's difficult to, have some specific advice how to get out of the system, because the decision is really complex and it requires careful consideration, and there are so many factors at play. And the more balanced the presentation is in front of the board, I think the better the process, and the process is fair for the accused.
And if, because as you mentioned, public safety here is one of the important factors that is being taken into account in these hearings. And obviously, I mean, the level of violence that is displayed during the year, because there are yearly reviews that are made just to get an updated decision about what to do with the client. But I mean, for the board to decide that there is no public safety, does that mean that there should be zero display of violence during the year? Or, I mean,
I think there should be, again, going back to that legal test, even if there are some incidents or
mhm,
some presentations during the year that indicates some instability or some degree of violence, I think it's a matter of, is that enough to meet the threshold for the legal test for significant threat to the safety of the public? And it is a legal test that is informed by clinical data. So we as experts, we can only provide all that data. We can say this is either severe degree of violence or moderate degree, and we can also provide context to the incidents. Just like back to your question with respect to criminal record, looking at criminal record that
mhm.
just data points, we need to understand the journey, what's behind that criminal record. Same goes with the last reporting year for mentally disordered accused or NCR accused that is in front of the board, to really understand why that individual had those incidents, what provoked, or why he or she responded certain way. So it's providing really context and understanding of those incidents, and the board needs to consider it when they answer that legal question. So it's very clinically informed, but the threshold is legal.
Okay. All right. And Mariana, because I don't want to take more of your time, but there is one last aspect that I did want to cover with you, because in addition to doing your work as a forensic psychiatrist and doing all these assessments and reports and testifying in court, you're also an educator. So if you can just take a few minutes just to tell us a bit more about your role as an educator.
Well, I think going into medicine, we really have uh, to encourage our future colleagues and currently trainees at different stages of their training to really understand what we do. So in my case, I mean, I think it goes for say, any doctor, and I will be biased. I'll say I love what I do. I
Mhm.
love my work, and I think any trainee that I work with, I really try to demonstrate what is forensic psychiatry, what is that we do that really makes it special, interesting, and a good choice for career and life as a professional. So in addition, I think forensic psychiatry, anything you say forensics is carries degree of stigma. So same
Yeah.
comes to training and
And
medical.
criminal as well. Yeah.
So medical students or any trainees or undergraduate students, if you mentioned anything related to forensics, it either somewhat scary to them or unknown. And my job as educator is really to show them the breadth of the field and work um, and practice that we have and how it can really impact individual um, groups and society as a whole at different levels. So I think it's important to really enhance understanding among undergraduate, graduate, and postgraduate trainees about the area of forensic psychiatry. We do have ongoing challenges sometimes to really maintain enough workforce and to really have enough experts available
Yeah.
to work with your colleagues. So my hope that by doing a little bit that I do with trainees that I work, I hope to enhance interest and to bring more people into this field because it is, in my opinion, the best part of psychiatry is forensic psychiatry.
Yeah. Well, I want to thank you so much, Mariana, for taking the time today to chat with me about what you do and to give us more information and education about the forensic psychiatry work from your perspective. I mean, we see it. I could speak as a defense lawyer from a defense view, but it's always nice to hear directly from a practicing forensic psychiatrist about what you're looking for, how you do your job. So that's really very interesting. And I'm sure many of our viewers will be interested in hearing what you have to say. And I really wish you the best. And I hope we'll have more interviews in the future to talk more about what you're doing and what you're continuing to do for your profession.
Thank you so much, Maya. Thank you for giving me the opportunity to talk about the field of forensic psychiatry and really to reach out to the group that I work with, criminal defense lawyers. Thank you.
Well, we're happy to have you as our guest here, and I hope to see you soon again, Mariana.
Thank you, Maya.